after they've tried everything else. And in this case, the Liberal government has definitely tried everything else to avoid action on foreign interference over 9 years. But with C-70, they've finally responded to pressure from the opposition and from the public. Conservatives don't want to let the government get away with sitting on this bill. After 9 years, we've had enough delays. We will push for anti-interference measures to be passed and in place as soon as possible. Now, one important flashpoint for the foreign interference conversation is Hong Kong, because Hong Kong's national security law makes absurd claims of universal jurisdiction, even claiming that if a Canadian in Canada makes statements that are deemed to violate Hong Kong's national security law, they could be charged and even rendered to Hong Kong while traveling in a third country. The manager of Hong Kong's Economic and Trade Office in London has been charged with spying. I've heard concerns from the Canadian Hong Kong community about the activities of the ETO in Canada. Hong Kong is no longer meaningfully separate from the mainland, which raises questions about whether these offices have any legitimacy anyways. So is the government reviewing the activities of the ETO as they relate to foreign interference?
Mr. Chair, this would be a question that would be better addressed by Global Affairs Canada.
Okay, no officials have a response on that? Okay, I would welcome a response in writing if you're able to communicate with your counterparts, because I do think it's relevant to our work today. I have a specific question for CSIS about a personal example and information sharing. As you know, my personal email was targeted as a result of my involvement with the Interparliamentary Alliance on China. The Government of Canada did not have my back. They didn't tell me about this threat or how I could protect myself. I'm a vocal member of the opposition, often critical of the government, and the government didn't report the information to me in a way that would have helped me protect myself from foreign interference. The government didn't have my back, but our institutions should have. But unfortunately, CSIS did not have the legal authority to share information directly with me as per the current law. If the changes of this bill had been in place, using my experience as an example, would CSIS have had the authority and been able to simply communicate directly with me right away about these threats and what I could do about them?
I think there's a specific question about the incident itself, and clarity needs to be provided a little bit insofar as the service is not the lead for cybersecurity for the Government of Canada, and I think this issue is relevant to another committee study, so I won't address that specific fact. But on the broader question around information sharing, certainly the service has some significant limitations in the disclosure of information collected in its duties and functions with anyone outside the federal government beyond law enforcement effectively. And so with amendments in the Act, there would be a clear authority to engage outside the federal government for the purpose of building resiliency to threats. And that could be an early, preventative, proactive kind of disclosure of information informed by our investigations. Where information has a personal or private element, the minister would determine that information could be disclosed if it was in the public interest. I don't want to really speculate on a specific scenario such as this one with hindsight, but I do think this would improve our ability to engage.
I understand, but just to drill down, so if there was a threat to me as an opposition member of Parliament that you became aware of, it sounds like even after this bill is passed, you would need the minister's determination that telling me was in the public interest before you could tell me. You wouldn't have the discretion to say, Mr. Genis needs this information right away because it's relevant to his life.
I would correct that presumption. In fact, the service, if there were a manifest threat occurring under its threat reduction mandate today, it could disclose information for the purpose of reducing a threat when the threat is unfolding, active. The amendments in the bill do something different. They enable an earlier and broader engagement for the purpose of building resiliency to threats before the threat
with
is
ministerial
real.
consent, though, or not?
No. No ministerial consent required.
Okay.
But no disclosure of personal information.
Okay. That seems like a gap to me, but I'll go on to one more thing here. Just following my general skepticism about the government's will to address this, why the requirement of Attorney General consent, and what would happen in the case where the Attorney General might be in a conflict of interest, such as where the Attorney General might have personally benefited from foreign interference in his or her own riding?
Thank you for the question. The requirement of Attorney General consent already exists in the SOIA, and so the new offenses which would be integrated into the SOIA would, that requirement would continue to apply. In general, the requirement of Attorney General consent applies to ensure that there is the proper assessment of the key elements of whether there's a reasonable prospect of conviction and the public interest in proceeding with a prosecution, that assessment is taken at appropriate level given the context of the interests at stake. And in practice, in our system, that Attorney General consent is usually exercised by the Director of Public Prosecutions.
Thank you, Mr. Dennis. We go now to Mr. McDonald. Mr. McDonald, please.
Thank you, Chair. Thank you, the witness, for being here today. I just want to follow up on possibly the regulatory framework from each of your departments. Can you provide any examples of the regulatory framework that you're dealing with?
Maybe, is your question, Chair, directed at the regulatory framework that would apply to the Foreign Influence Transparency Registry? So the regulatory framework that will underpin that will need to be developed. But to give you, to respond to the question, Chair, for example, there are parts of this that need to be further identified. For example, administrative monitoring penalties is a tool that will be available for a commissioner in terms of imposing an amount of penalty if...
Point of order, Chair. I can't hear.
I apologize.
Could you
please
start again,
please repeat your answer
if you don't mind?
Absolutely. I think we've spoken, Chair, about a few things in the legislation for the Foreign Influence Transparency Registry that would require the bringing into force of regulation. For example, individuals who are required to register will have to supply the commissioner with certain type of information that will be designated by regulation, and could include things like very obviously name, address, and things like that, but also the nature of the agreement and who the agreement is with. It would also establish via regulation what kind of information the commissioner would be obligated to publish online in a registry to basically render effective the transparency. It would also determine the amount of monetary penalties a commissioner can impose once they have issued a notice of violation. So those are some of the key examples of things that would be brought in via the regulatory framework. It would also specify the kind of parameters for sharing information with other agencies. It could also, you will have noticed, there are very few exemptions in the bill that would apply if adopted. The regulations do allow the Governor and Council to bring in more exemptions, although the bill is designed in a way that there are very few exemptions because the bill wanted to create the maximum or the minimum amount of gaps or ways of escaping registration. And so some of those examples are what would be required in terms of regulatory framework to implement the legislation.
Thank you, Mr. Bilodeau. And I'm going to ask change direction a little bit, but can someone describe some of the defense mechanisms for the people at home, just to briefly describe the defense mechanisms that could be used? And I also want to state that CSIS has been around a long time and has been doing great work. Obviously, when we had over 5 million cyber attacks from September to December in 2023, I think it's really important to identify the work that you've presently done. Obviously, technology is changing in the digital world, so it's changing very quickly. So I want to identify something else too, that someone said that it's in the bill, I believe, 5 years review. Is that correct? Is that too long?
Thank you for the question, Chair. The 5-year review is proposed there. It's consistent with what exists in legislation, and we mentioned earlier how in viewing what other partners are doing around the world, in Five Eyes particularly. So that's a proposal there. It wouldn't, of course, preclude the Parliament's ability to study or to bring legislation beforehand. What it does do, though, we think, and why it's proposed, is that it allows for the government to propose legislation on a clock and to have a review of to ensure that CSIS's authorities are fit for purpose, whether its authorities remain justified, and provide a regular review outside, hopefully, of emergency situations. And it also allows for civil society and stakeholders to galvanize as well, to prepare themselves to contribute to that debate and that discussion in hopes of maturing a national security conversation in the country.
Half a minute.
And quickly, I don't have much time, but I did mention defense mechanisms, and perhaps I won't get to all of it, but is there anything in particular that stands out from CSIS that maybe the general public should be aware of when they're reading the stuff in the media and the misinformation that sometimes has been directed from other sources?
I think the provision that stands out that would stand out the most, or that would be the most of interest to Canadians generally, is the information sharing provisions and the amendments in the Act with respect to that. The ability of CSIS to share information outside of the federal government is something that we think a lot of Canadians, especially those in important sectors of the economy, for example, in the academic sector, and in communities as well, who are victims of disinformation campaigns, misinformation campaigns. We think that'll help build that resilience and help protect Canada's democratic health as well.
Thank you, Mr. MacDonald. So that brings round 2 of questions to a close. The following round will be the same pattern as the one we just had, but I'm suggesting we take a short break. Is the committee in favor of a 5-minute, 10-minute break? I'm sorry? Keep going? Okay. We go now to Mr. Shipley for 5 minutes.
Thank you, Chair. And my first question, I'm going to build off of what a couple of my colleagues, Mr. Cooper and Mr. Caputo, were speaking about. More really of time is of the essence with this bill. We are aware of the last few elections or more. There's been foreign interference situations with different electoral districts across Canada. So we know there's a looming election. We heard the date this morning, October 2025. That's not that far away. We've also then heard that it's going to take approximately a year to really implement and get this registry set up. My pre-political life, I was in the private business world, and in a year, you could incorporate a company, find a facility, bring in inventory, hire employees, get customers, ship, and start making profits in a lot shorter time than a year. Could maybe someone from each department please enlighten me how this implementing could possibly take close to a year or more?
Thank you, Chair, for...
Just for context, so the amendments to SOIA will be in force 60 days after royal assent and CSIS. So that doesn't require the timeline. If we're creating a new regime, which is the commissioner, then there's some delay. So I just want to have a broader perspective on the bill. But no.
Thank you for that, Sebastien. The year estimate is based on the number of regulations that need to be brought forward and promulgated by the Governor and Council. It also requires actually setting up an office. While the proposal in the bill is to establish it within a department, it does require staffing up an office, for example, hiring a commissioner. We are going to be dealing with Canadians' private data in establishing the registry. That requires a privacy impact assessment to make sure that we're dealing with that data in a way that is appropriate and consistent with privacy laws. It also requires establishing an IT platform to receive information for the registry and then publish that information back out to the Canadian public so that they can consult the database. It will require developing guidance for Canadians in terms of expectations. For example, if we look over at our friends in the UK, the law became or came into or received royal assent last summer, 2023. They issued guidance in February of this year that is intended to educate people on their obligations with regard to the registry. The goal of the registry is to increase transparency, and one of the key ways of doing that is by clearly communicating to Canadians who might be in arrangements with foreign states. And because it is country agnostic, that encompasses every foreign state. What are their obligations in terms of registering? And so there's a significant part of this that is educating the Canadian public on their obligations. And building guidance in will make sure that people know what their obligations are. And so those are some of the steps that will need to be put in place so that we have a proper functioning registry when it gets launched.
Thank you for that. Is there anything specific this committee could do here today or in our meetings coming up that we could help anybody assist to speed this up at all? Is there anything specific we could do?
I think we're at your disposal. We will be here to support the work of the committee and answer your questions, and we'll stand ready at any point in time to support that work.
Okay, thank you for that, and hopefully it goes as quickly as possible. Speaking of the registry, there's been some concern that some foreign governments may be able to exploit diaspora communities by enlisting volunteers rather than paid agents, which may bypass the need to register on the foreign agent registry. Has that been thought of at all? Is that factual?
Yeah, so the registry does not require the payment. Their legislation, the bill, does not require the payment of monies for an arrangement to be captured by the registration obligation. It can be an understanding of doing a favor or anything like that. It does not require payment.
Thank you. And has a charter statement been completed on this legislation?
Thank you, Chair, for your question. So, as is the normal practice, the Minister of Justice will be tabling a charter statement that will outline the potential implications of rights and freedoms protected under the Charter by Bill C-70. I don't believe it's been tabled yet, but as per the practice, that would be our expectation.
Thank you.
Thank you, Mr. Shipley. We go now to Mr. Gahir. Mr. Gahir, go ahead with 5 minutes, please.
Great. Thank you, Chair, and thank you to the officials for appearing before the committee. So my question is sort of for all the witnesses and whoever thinks that they're best to answer should answer this question. But we know that under the proposed framework, individuals or entities who enter into an arrangement with a foreign principal and undertake activities to influence a government or political process in Canada would be required to publicly register. Could the witnesses talk about the penalties that would be imposed or the consequences that could be imposed if that entity or individual does not register?
Thank you, Chair, for that question. The legislation proposes a compliance or some number of compliance regimes, but I think I'd like to start the answer by maybe giving an example, and might be the best way of appreciating how the bill proposes this to work. Somebody may, for example, forget to register their activity. Good faith error. The commissioner would have an ability to, if they so desire, issue a notice and say, "Sir, madam, company, you should have registered under the Foreign Influence Transparency Registry." That person brings themselves, says, "You know what, I should have," brings themselves into compliance by registering. There will be instances, I'm sure, where somebody will deliberately not register or obfuscate. The commissioner at that point will have a decision to make following an investigation whether or not to deal with that breach or that contravention, either from a civil perspective or a criminal perspective. And if the commissioner decides that the best course of action is to issue a notice of violation, in addition to issuing that notice of violation, could impose administrative monitoring penalties, the amount of which will be determined by regulation. The commissioner would then also be obligated to publish that notice of violation so that Canadians are made aware that an individual or a company failed in their obligations to register. Of course, at that point, there's also the ability of an individual found to be in violation to refer to the federal court for judicial review. That's part of is proposed in the bill. Finally, there are criminal sanctions that could be imposed. If the commissioner believes that the breach is so severe that it warrants criminal investigation, the commissioner could then refer the matter to a police of jurisdiction, the RCMP, for example, where the police service, the law enforcement agencies would investigate and then work with prosecutors, but that would be done independently by the police at that point. So that gives you a bit of an idea of the scope Obviously, one big
Sure.
part of that is education up front. We're hoping to make sure that people comply as much as possible.
Great. Thank you for that comprehensive answer. I think I want to take this, I'll posit my own hypothetical. Let's say that there is an individual, that individual is a foreign agent, and there is a conviction that sort of will come from that, that will lead to criminal or potential conviction that could arise, that could lead to jail time. What level of arrangement is required between that person, that individual in Canada, and that foreign principal that is overseas? And knowing that there's probably layers of separation that is between them, what level of arrangement is required? Is it implicit? Does it have to be explicit? What is that bar?
It's a very good question, and Chair, I'll leave the issues of beyond a reasonable doubt and things like that aside. But establishing whether an arrangement exists between an individual and a foreign state will be a matter of the facts of the situation. The commissioner will have tools, investigative tools, the ability to compel information to try and determine the relationship between an individual and a foreign state. It is not always easy. I think you are correct in making that statement. But there will be tools. There will be the ability to work with intelligence services and law enforcement to get information to try and make that determination. But at the end of the day, it will be a collection of facts to determine whether or not there is an arrangement. And as I said earlier, it does not need to specifically be a written contract, although obviously that makes it a lot easier. But it can be a totality of circumstances, factual circumstances that can lead to a conclusion that there was an arrangement, and ultimately would be up to a court to decide whether or not that burden's been met.
Great. Sure. Just how much time do I have left?
35 seconds.
35 seconds. So I guess I just want to end with a statement saying that this does worry me that foreign agents could operate through a chain of command, and it's very hard to trace that chain of command back to the individuals that are overseas and acting as a foreign principal. So I think there should be emphasis placed on the actual conviction, because if you can't get a criminal conviction for an individual that is engaging in these acts, then what's the deterrence? Deterrence is basically just the legal expenses to deal with the embarrassment from and the inconvenience from a trial. They're not going to actually get convicted if that chain of command can't be traced back. Thank you, Chair.
Thank you. If anyone wishes to respond, they may.
No, we take note of the concern, and I would say that the element of all this that is key to Foreign Influence Transparency Registry is bringing transparency, and even bringing sunlight to associations is a key valuable tool, and I know that the service agrees with that as well.
Thank you.
Monsieur Villemure.
Mr. Villemure. 2.5 minutes. Thank you very much, Chair. 2.5 minutes, very fast. Concerning the... you can't escape, sorry. With regard to the Commissioner on interference, I would like to know why they would be with the Public Safety Ministry. You say there are a lot of measures in place already, but I'm concerned because we were talking about overlap, and would the Commissioner be completely independent? And but independent, it depends on the individual. And I'd like to come back to this post, and I'm not assuming there would be any interference from the ministry or the minister, but how can we ensure that the Commissioner would be independent and in the selection of the Commissioner as well? And what procedures or guarantees are there? Thank you very much for the question. And as I said, that it will be a decision by Parliament to adopt the law, and there could be amendments, but the bill provides for independence for the Commissioner to take decisions with regard to the implementation of the law and what inquires to continue or to not continue, and all of this work, all these decisions will be done independently. Sorry, but there's independence in the actions, but there's no independence for the ability. But the independence, the Commissioner must make a report every year to the minister, and that will be provided to Parliament every year. So the Commissioner is responsible to the minister and to the Parliament. But why not include political parties in the bill? The bill includes the consultations for for example, financing of public parties by foreign actors. I think that if I've understood the question correctly, the political process defined in the law includes, for example, if there were interference or by foreign actors, this would be something that would require there be a registration with the Commissioner. Thank you very much for reassuring me.
Merci, monsieur. Mr. McGregor, please go ahead, 2.5 minutes.
Thank you, Mr. Chair. At risk of repetition, I want to delve again into the definition of arrangement. So let's just, for argument's sake, say that I'm an ordinary private citizen, and by virtue of my last name, I have an association with the Scottish government. And I communicate with a public office holder about a proceeding in a legislative body. I'm just trying to see what's my level of association that would trigger me having to register.
Thank you very much, Chair, for that question, and it's a good question to make I think what is an important point. This legislation isn't about regulating what people can say or not say in advocating for positions. So I think that I want to make sure that is completely clear. Where it imposes a degree of transparency is where that advocacy is being made on behalf of a foreign state or an association with a foreign state. And so the best answer to that is if you are a private citizen, Mr. McGregor, and you're looking to, you want to meet with a deputy minister because you think that exposition by your government would be helpful, and you're not doing it on behalf of a foreign state, but you're doing it out of love for your country, for example, that doesn't require registration. But where you have an understanding with a foreign state that you're doing that for them or in association with them, that is what triggers the requirement to register.
Thank you. And then going on to the section 27 where it talks about regulations, can you walk me through those in terms of the different classes? Is there obviously going to be sort of a listed difference between someone who has an association versus someone who's acting overtly under the direction of a foreign entity?
Thank you again for that question. And Section 27 sets out the regulations. 27A adds potential classes of individuals that would fit the definition of public office holder. It's meant to identify classes. It's not meant to identify countries or organizations. It's meant to make sure that there's enough flexibility in the legislation through regulation that if we believe that a certain group of people should be captured by the registration obligation, that there's an ability in the regulations to do that. The definition of public office holder is well known. It's established in the Lobbying Act. It is fairly broad, but if we were come to realize that it would need to capture other classes, this would be the way to do it.
Thank you, Mr. McGregor. We go now to Mr. Cooper. Mr. Cooper, 5 minutes, please.
Thank you very much, Mr. Chair. Two of the public safety officials, the coming into force of the Foreign Influence Registry is subject to an issuance of an order in council by the Cabinet, correct?
That's right.
That's right.
And there is no date prescribed for when that order in council would be issued, is there?
That's correct.
So there is no date, correct? Okay. And so it would be correct to say that there's nothing in the legislation that would prevent the government from differing in issuing that order in council.
It is up to the governor and council to decide when that is.
Now, with respect to, so yes, and the answer is yes, there's nothing to prevent the government from differing.
Yes, it's up to them to decide when.
Okay, thank you. And there's much that has been left to regulation, including with respect to administrative penalties, as well as the contents of what must be disclosed to the commissioner. So once the bill passes, assuming that it does, I think it will, is there going to be another lengthy consultation process for what should be included in the regulations. We have seen that with respect to other bills that have been introduced and passed that have been delayed in terms of implementation because of another extensive consultation process. So is that in the works?
Thank you for, well, I don't know if you want to answer
No, I
first.
just want to say that I sort of disagree with your premise. I think this bill, FITA, doesn't leave a whole lot left to regulations. A lot is in the statutes. And no, so the regulatory framework will be quite contained if you look at comparative other pieces of legislation. But in terms of the process, Richard.
Thank you. And some of them are simpler than others, determining the amount of penalties that corporations or might have to pay in terms of an administrative monetary penalty, or individuals. Sometimes there's a different initiation in regime, so that's fairly straightforward. But to answer your question about consultation, some of them might require consultation more than others. Some of them are very technical, but that is something, for example, if we were to consider adding classes of exemptions or another exemption to the regime, you can imagine that would require consultation.
We anticipate that there would be some sort of consultation process that could potentially take some time because certain aspects of it may be more complex than others.
It is possible that there will be some consultation activities on some
Okay, so I think this just underscores that we have more delay and underscores why time is of the essence, and it just underscores that this should never have, we should never have been here, and the reason we are here is because this government failed to act, failed to move forward with establishing a foreign influence registry year after the consultation process has ended, and only now are we beginning to study a bill that is, as of yesterday, the first day of debate at second reading stage. Moving on to the foreign influence registry provisions, specifically the definition of public office holders, I would note that, for instance, appointees of the federal cabinet constitute a public office holder, but provincial cabinet appointees of provincial cabinets are not included. Similarly, officers, directors, and employees of federal boards, commissions, and tribunals constitute a public office holder, but the same would not seem to apply with respect to directors or employees of provincial or municipal government corporations or agencies. So why were those left out?
So thank you, Chair, for the question. I would point out that the legislation provides that it would apply to provincial territorial governments when that is brought into force. Same thing with Indigenous governments. They would apply to them when that is brought into force.
I understand that, but and it applies to federal government as well, but I cited two specific sections in terms of what constitute public office holders. There appears to be a gap there. I want clarity as to whether I'm correct in that interpretation, and if I am, why were those left out?
I'd have to go back and look at the language of the provisions. I would say that the legislation allows, through the regulation, of adding classes of people. And if we became aware that there were a class of people that needed to be captured, it can be done.
Well, very simply,
Thank you, Mr.
appointees of
Cooper.
the federal cabinet, but
Thank you,
not
Mr.
appointees
Cooper.
of provincial government.
Thank you, Mr. Cooper.
So that would be part of the conversation. The reason we brought into force, or separately, the provincial and territorial components was to ensure collaboration with our provincial and territorial colleagues, so we could do that in an orderly way, considering that, and that can be part of those conversations. And I'm not saying it won't be. I'm just saying it's right now.
more
we're not
delay.
there.
Thank you, Mr. Cooper. That's enough. We go now to Mr. Arya. 5 minutes, please.
Thank you, Mr. Chair. My question is generally to all three witnesses, all three departments. Have you guys, I know that you mentioned that the foreign interference laws passed by our allies, the Five Eyes, including Australia, has been looked into. Are you guys aware of the first case in Australia that was tried, which was reported by New York Times on March 16th this year? You can start with CSIS. you are aware of that article. And I'll just mention what New York Times said. It's not me, but what it said was the first case tried under Australia's foreign interference laws has raised tough questions about the breadth of the regulations. I'll just quote some sentences from the article, and I would like to know from you guys if that is what can happen here in Canada under this new law. The fundamental thing about that case is the police officers asked the man what he meant when he said that involving an Australian government minister in a charity event could benefit us Chinese within the courts. Was he talking about mainland China and the Chinese Communist Party or the local Australian Chinese community? Depending on the answer, depending on the judge, jury, or the government officials, whether when he says us Chinese means Chinese government or us Chinese means us Chinese diaspora. Depending on the answer, yes or no, he could face 10 years in prison. This event is about $225,000 donation to a community hospital, which, according to prosecutors, would at some point have become the basis for a pro-China pitch to a local member of parliament. So my question is, do you think it is possible that this case can happen in Canada under this proposed law?
Thank you for the question, Chair. One of the discussions around this, of course, is the very gray nature of foreign interference and making those connections. What is included in this bill is a package of measures that together seek to provide transparency around foreign interference activity. Help us.
Maybe I can ask the Department of Justice.
I don't have the details of the case specifically, but what I can say, if there's an arrangement that's being made within a foreign principal and someone in Canada to make that advocacy, that
please look up the case and get back to the committee with an answer.
Sure, absolutely.
Okay.
Yep.
Then the Department of Public Safety and Emergency Preparedness.
Thank you for the question. I'm speaking on behalf of the Department of Justice, but I can address the question. Certainly, we have benefited from having seen the experiences of the Australian legislation and the bill reflects efforts to learn from the experiences of Australia. In particular, some of the definitions in the Australian legislation have been criticized as being vague and not providing sufficient detail to guide law enforcement and prosecutors. We took note of that in the design of the current legislation.
Again, I'm quoting from the article. It has become a cautionary tale for the country's large diaspora communities. In theory, the new laws were an effort to defend democracy against foreign influence. In practice, they have raised tough questions about when such intentions might drift into xenophobia. So how are we give assurance to the diaspora communities in Canada that this will not happen here in Canada? We'll start with CSIS again.
I can start by saying maybe that the consultations that preceded the introduction of the legislation were extensive and included discussions with a wide range of diaspora communities, community leadership, including, for example, the cross-cultural roundtable on security. So we've heard these concerns, and they've been expressed loud and clear during the consultation phase of the bill, and that input that was provided by these communities and by our partners and stakeholders have been incorporated into the drafting of the legislation in a way that we expect will prevent the kinds of issues that you're raising this morning.
Okay. Thank you, Mr. Arya. So that wraps the third round. We'll start a fourth round following the same pattern, except that this time I think we'll run out of time by the time we finish with Mr. McGregor, so we'll end it there. So, and also, before we rise, I want to encourage all parties to get witness lists to the clerk, hopefully by noon tomorrow in some priority fashion, so that we have a sporting chance of setting up meetings for next week. The clerk will do his best to organize things in terms of who is available and when they can get there, and in terms of the priorities that we provide to him. Having said that, I will now go to Mr. Caputo for 5 minutes, please.
Thank you, Chair. And Mr. Biddle pointed out that I was incorrect during my last round, so I should correct the record that the NDP leader's pension will vest prior to that date. It was 25% of his caucus that I should have been referring to. Now, in any event, when we're talking about sabotage and the sabotage-related offenses, we are speaking about infrastructure and critical infrastructure. So the question I have is this. I'm going to see if I can find the exact wording of the provision where it talks about essential infrastructure and the definition of that essential infrastructure. My question is whether we're talking about, for instance, under section 52.1 sub 2, transportation infrastructure, information and communication technology infrastructure, et cetera. We have, it looks like 8 or 9 enumerated grounds. 8 enumerated grounds, and then the regulations can add other infrastructure. So would the offense of sabotage apply only to infrastructure that has actually completed, as in other words, like an existing rail line or existing telecommunications line? Or what about when a private company or the government is in the process of planning or constructing that infrastructure? Would the offense of sabotage apply to that as well?
Thanks for your question. What I would draw your attention to is the definition of essential infrastructure in the bill. And what it says is that it means a facility or system, whether public or private, that provides or distributes services that are essential. So I think it would be a question of the specific facts and the operational state of that infrastructure. In theory, something that is still under construction is not actually at that point providing or distributing what we've defined as essential infrastructure here. Obviously, interference with that type of thing may be covered under other offenses in the code, but may not necessarily fall within the offense of sabotage related to essential infrastructure as in the bill.
Okay, that's interesting. I mean, to me, that's a bit of a gap because foreign interference could certainly seek to undermine that which is being built in Canada for infrastructure. So that might be an area that that should be considered for amendment. One of the questions I have is in relation to the offense of sabotage as well. The offense has a 5-year maximum, and this to me feels like a fairly serious offense. Is there a reason why this isn't a higher maximum for sentence?
Just to correct, it's a maximum 10-year sentence for sabotage when committed by way of indictment.
Oh, okay. I'm sorry. I thought it went from 2 years to 5 years, but I must have misread that. I apologize. Yeah. Okay, thank you. I believe Mr. Jennis is really chomping at the bit here to get in a last couple of questions, so I'll cede my time to him.
Always. Thank you, Mr. Caputo. One gap in terms of the response here has been around people facing coordinated discrimination based on political activity, people in diaspora communities who are involved in pro-democracy activity, for example, who then face various forms of discrimination that may be officially or unofficially coordinated from abroad. One instance I heard of recently, for instance, was someone involved in pro-democracy activism in terms of Hong Kong who faced negative consequences from their landlord as a result of it. Now, I have a private member's bill, C-257, that would add political belief and activity as prohibited grounds of discrimination, which I think is one solution. That wouldn't apply in provincial jurisdiction, but it would apply in federal jurisdiction. You can imagine similar models being adopted provincially. But I think this is one problem that Bill C-70 does not solve. I'd be curious for your feedback, especially the justice officials' feedback on this, and what steps could be taken to protect people from discrimination that may be coordinated from abroad and may respond to political activities that they're involved in here in Canada.
Thanks for the question, Chair. I'll save your remarks, and if my colleague has more to supplement, he can. I will admit I'm not familiar with your private members bill, but I'm going to guess based on how you've described it that what you're talking about is adding political belief to the Canadian Human Rights Act. Is that correct?
Exactly.
Okay. So the Canadian Human Rights Act is a little bit different in the sense that it applies as between relationships between private individuals and discrimination that may take place there. So the stuff that we have in the bill would not cover those scenarios unless there is a link to a foreign entity, if that makes sense.
Okay, so if there was a link to a foreign entity, would it be covered if a foreign entity was, if the person who was doing the discriminating was involved or connected to a foreign entity in some ways, but that was in a private relationship? Would the bill impact that, and how?
That's
So-
your time. Witness may answer.
So maybe just to clarify terms, so discrimination normally is how you provide goods and services in the sense of the Canadian Human Rights Act, right? So I think my colleague can supplement, but I think what could potentially apply here is, for example, if you are doing something as the landlord at the direction, benefit, in association with the foreign entity, that could potentially be covered by the new general foreign interference offense.
Thank you.
Thank
Oh,
you.
sorry.
Just briefly, if the form of the discrimination rises to intimidation, threats, violence, or coercive behavior that doesn't give the victim a choice in the matter, then certainly the new and newly amended offenses in Section 20, 20.1, 20.2 could apply to those circumstances.
Thank you.
Thank you. We go now to Mr. Gahir. 5 minutes, please.
Great, thank you, Chair. So I understand the sensitivities around asking this question, but could the officials please speak to the intelligence gathering mechanism to establish that there is an arrangement between a foreign principal and an individual or entity here in Canada? What's involved in that intelligence gathering?
Thank you for that question. I can start off, and I won't speak to the collection capabilities of intelligence partners, but I will speak from a perspective of a client or a consumer of intelligence. We get intelligence shared with us, and that can be informative. Again, it depends on the nature of the intelligence in terms of its corroboration, its value, how it can be relied upon, caveats associated in terms of its use. And so there's a structure around intelligence, how it's shared with law enforcement. I am not an expert in that field. I would defer to my colleagues from the service or from the Department of Justice on that, but to maybe clarify or take it away. The commissioner does have investigative powers to collect information, but it could also receive intelligence that has been collected by partners. And so there's a distinction there, and obviously when you get intelligence, there are limits to how it can be used that are imposed by the process.
Okay, so is there a mechanism to ensure that there is information sharing between different government agencies? So like, what if different agencies have different pieces of the pie? What mechanism is there to ensure that they sort of combine that together to see the entire picture? And maybe that reaches that bar where they can launch an investigation.
So the service, for example, is unlimited in the disclosure of information and intelligence to the Government of Canada. That's its principal principal client, and of course it can disclose intelligence widely. Are there processes in place for ensuring sharing is wide? And yes. And are they perfect? No. This is an area that has come up in the recent public inquiry report, and I think we have a significant commitment to address some of the issues in this respect. When it comes to sharing with a particular body, it's slightly different from more routine intelligence gathering and sharing. We will, I assume, I'm guessing, have to have some mechanisms, an MOU, a process, a structure for doing this. It's not until the bill becomes law. That's not the current focus. But the broader integration of the security and intelligence partnership and key clients is very, very strong at all levels. And the sharing of intelligence is a huge priority. There is some process improvements that can be made.
What I can say is that, essentially the service has the legal authority to share. The legislation for FIDA sets out that the commissioner can receive the information and consume it and use it. There will need to be arrangements, the MOUs that established between the two organizations for receiving the information, and also make sure that the classified systems are in place to receive and store the information. That's one of the reasons why the commissioner would be housed in a department to make sure that we optimize the use of the information sharing arrangements and the infrastructure that is there for the intelligence to be shared with the commissioner.
Great, thank you.
Mr. Gahir, you have 1 minute left, if you wish.
Oh, I have 1 minute. Okay. So another question that I wanted to ask is, who are the entities that the officials believe or the government believes are most likely to register under this new act? Is there sort of a preconception of who's likely to register?
It's a good question. We would expect, Chair, anybody who has an arrangement to register. Obviously, there are people who, by the nature of their business, work with foreign governments legitimately that would want to or will be required to register. And so if you are in the business of advocating on behalf of clients and you're doing that on behalf of a foreign state, you will have to register with if the bill is passed, with the Foreign Influence Transparency Office. And therefore, we expect, obviously, that group of people that is well versed in registering for the Lobbying Act to also be required to register when they're in an arrangement with a foreign principal. That would be one example.
Okay, if I can just quickly get in one question. If they have registered, and what's the bar for those individuals and their activities being monitored to see if they're actually, they've registered, but are they now abiding by the laws that this country has, or are they skirting that even though they have registered?
I think it's a good question, Chair. The legislation does have provisions requiring updating of information to the Commissioner on their activities. That will be detailed in regulation.
Thank you, Mr. Gahir. C'est maintenant Monsieur
now, Mr. Villemure. Thank you. 2.5 minutes. Thank you very much. Another question for public safety. When we read Part 1 of the law on CSIS, it means that they have to be able to get information from universities to receive Canadian funds. I'm not sure that all universities would be required to register. And are those universities some of the bodies that would be required to register? Thank you very much for the question. To take an example, if a university has an agreement with a foreign government for the activities under the laws and representing or communication or funding with a view to influencing a government official or a policy, the entity would have to register. But everything will depend on the type of relationship and the activities and the context for the university. So it's really, I think there would have to be all three criteria to be met, and whether it's a university, a public institution, or a private business. No, but the foreign entity, but the person who is influencing or who is someone who is in a university who is acting on the part of a foreign entity, the commissioner will publish this information, and there will be some transparency required with regard to the role of the foreign entity. But if this relationship will lead to a change in policy, would the foreign entity have to register? Well, it depends on how the influence transpired, if it was someone who is hired to implement this influence, but there could be some other provisions or situations that might be applicable beyond the registry. Can you explain this a little bit more? Or? But the law is fairly clear on the obligation to register and who is obliged to register. I think it's Article 3. There are criteria, and the commissioner. This is something that the commissioner can also seek to clarify, and the commissioner is responsible for applying the law and for entities meeting their obligations under the law and for their registration. And this is something that's in the law. Thank you.
Mr. McGregor for 2.5 minutes.
Thank you, Mr. Chair. I think this question will probably be to the Department of Justice, and I'm just flipping through the different sections of this bill, and the theme of my question is on legislative harmony and consistency. I want to draw your attention to the amendments to the SOIA, specifically on page 32 when it's talking about the application of the Act. There it makes specific mention of municipal, political, or governmental processes, but in Part 4 that is excluded. Likewise, if you look on page 31 of the SOIA, the definition of public office holder is quite thorough and very defined, whereas in Part 4, the definition of public office holder is not as thorough. And so I'm just wondering, from the Department of Justice's point of view, if we're looking at possible amendments to this Act, what is the preference in terms of making sure that these two acts are in harmony? Would you like us to be as specific as what's included in the SOIA when we amend Part 4? I'd just like to have some guidance on that, please.
Thank you for that question. The definitions that are used in SOIA are with the context of SOIA and the offense itself in mind, and were clearly inspired, as you note, from other provisions and other categories of public office holders. So the offense of interference with political or with political processes or governance involves a category of public office holder which I agree is quite extensive and in fact is open-ended to a certain extent as it's defined. That works well within the context of SOIA and within the context of that particular provision. The other categories of public office holder are designed to work well with the other regime. So that's what I would say. Yes, there are similarities, and yes, there are differences, but those are intentional.
Thank you, Mr. McGregor. So that brings our questioning to a close. I'd like to thank our witnesses for being so enormously helpful and for showing up on such short notice. It's really appreciated. I also would like, Mr. Villemure would like a few words with the committee, but before that I want to make sure to remind everyone that we need witness lists. Each party should submit their witness lists to the clerk in a prioritized manner. In order to schedule for Monday, he'll need them by, those witnesses by noon. Mr. McGregor, you had a question?
Yeah, Chair. Just given how heavy our workload is going to be next week, and given the timelines we're dealing with Bill S210, I'm just wondering if we have unanimous consent from this committee to ask for a formal extension so that we can give S210 proper study. Because C70 obviously is going to take priority of this committee. Can I get unanimous consent for that?
I've already had, there's no unanimous consent, so thank you.
Thank you.
So Mr. Villemure, please go ahead for a few minutes.
Merci, Monsieur le Président. Thank you very much, Chair. I'd also like to, given the our work, I would like to ask a unanimous consent whether when there is a panel for 2 hours. We could start back the time for questioning when there's only one panel present for the entire meeting.
We'll lose time. We'll lose time on it.
I should point out that what we've done today is fairly unusual for us. We were kind of rushed, and that the routine motions that we are operating under kind of proceed in this manner. I'm not sure if there is willingness to adopt that on unanimous consent at this point.